Thank you to Earthstrike for the opportunity to speak this afternoon. I very much appreciate that. So I've been asked to speak about the anti-union laws in Britain, and obviously that the main point of this is to think about how they incapacitate workers from taking strike and industrial action on issues that would be useful to the environmental movement. If you were to ask most union activists today what laws there are that stop them from doing what they would like to do in terms of taking strike action and organising more widely, I would suggest that most of them would say, well, it's pretty obvious, isn't it? It's the Tory anti-union laws of the 1980s. And while they would be right, they're only partially right. Because, in fact, we need to go back 115 years to 1906 to understand the legal framework that we as workers still operate under today. So in 1906, there was an Act of Parliament called the Trade Disputes Act. It was passed by a Liberal-led government. It was Henry Campbell Bannerman was the Prime Minister at the time. And the Act, the Trade Disputes Act, came about as a result of a dispute 5 years earlier, which was called the Taff Vale dispute, which is in South Wales. And in the Taff Vale dispute, a forerunner of one of the rail unions today was fined the sum of £23,000, which was a huge amount back in 1901, probably amounting to several £million today. It was fined that amount of money because it had undertaken strike action, and that represented the losses that the employer incurred, the £23,000. Turn to 1906, the Trade Disputes Act changed that situation. It meant that if a trade dispute was engaged in and certain rules were adhered to, a union could not be sued for loss of business that was incurred by that employer. Now, why is this relevant? Well, the first thing to say is that I have not mentioned that there is a right to strike in British law. I have not said that either that right to strike exists in the Constitution, which of course in Britain we don't have. We have no written Constitution, but neither does it exist in any basic law, fundamental laws that are part and parcel of how modern states exist. So in Britain, we have this very strange situation where unions have what's called immunity in tort, immunity in law, from being sued for loss of business. And they only have it when they engage in a trade dispute with their employer. Now, as Daniel Randall will point out later on, what this means is that political strikes are not lawful in Britain. There's no scope for lawful political strikes. And so obviously that meant that in 1926, the general strike was not a lawful strike. So we have this strange situation. It's not a situation that is comparable in most other European countries. Either the right to strike is in the Constitution, or it's upheld by, as I say, a basic law. And that's the case in France or Germany. So that's the framework we have. If you turn the clock forward over 100 years, and despite there being some changes to legislation that I'll mention shortly, it's still the case that you can be sacked for going on strike, which really reinforces the point that there is no legal right to strike in Britain. So let's turn back to the 1980s, because we have already this restricted framework under which workers can take strike action, and it's not for political purposes. It's only when you have a trade dispute with your employer, your immediate employer. So let's come to the election of the Conservatives in May 1979. Within the space of less than a year, they began to institute a series of laws which further narrowed down the ability of workers to take industrial action. They did this with the 1980 Employment Act, the 1982 Employment Act, the Trade Union Act of 1984, and an act in 1990 and a further one in 1992. Those are the main parts of the legislative programme that the Tories introduced. And most of the legislation that now governs this much narrowed ability to take strike action is found in the Trade Union and Labour Relations Consolidation Act of 1992. It in itself has been updated by the Trade Union Act of 2016. Again, I'll mention this in a moment. In fact, the Trade Union Act of 2016 was inserted into this 1992 Act. So in terms of what those acts in the 1980s did, what was that? Well, it used to be the case prior to those acts coming in that workers were lawfully allowed, and when I say lawfully in this situation, there was a grey area. It neither meant there was the positive right to do it, but nor was there restrictions on doing it either. So it was that kind of grey area in the middle, another unusual feature of British law. They were able to take secondary action. That means that they could take strike action or other forms of industrial action that were not at their workplace. And most obviously, that could involve solidarity action. So one group of workers taking action on behalf of another. The classic example from the 1980s is that miners in South Wales came out and striked to support the nurses in support of their pay claim. And I think that was 1981 or 1982. Then there were restrictions on picketing. And as with most of these restrictions, they were targeted on those forms of tactics which were most successful in winning workers' disputes with employers. So picketing, mass picketing in particular, flying picketing as well, or flying pickets, were also used, and those were all restricted. So that now we have a situation where lawful picketing only amounts to picketing your own workplace, but also only doing so with 6 people. Then there's restrictions on balloting, or the imposition, rather, I should say, of ballots with certain restrictions about how the balloting was to be done. And essentially what this means is that through the balloting requirements that still exist today, a union has to jump through a whole series of hoops if its members want to take a strike action. They must give notice of a dispute to the employer. They must give notice of the intention to hold a ballot. They must give the result of the ballot and a breakdown of where the workers or the members were that voted for it. And they must then give notice to the employer of the intention to take the action and where it's going to take place. And all these small details are important in building up a picture to show that the state, directed by the Conservative government, has intervened to support employers, because it means that strike action under this rubric becomes less and less of requirements. And to bring the story up very much up to date, in 2016, a new Trade Union Act was passed in Parliament. And what that did was it meant that if a union is to have exemption in law for loss of business, then it must hang in the ballot. On top of that, of course, had to vote for industrial action. The 50% of people voting for action, when there was a 50% turnout in the overall ballot, also must had to equate to 40% of all those entitled to vote. So in the fire service, in parts of the health service, there's a double threshold that has to be gone through. So what this means is that not only is taking industrial action increasingly difficult in Britain, but you also start with the kind of first premise that you're not allowed to take industrial action for political ends. Political ends could be deemed to be those where it's not an immediate dispute with your employer. And there have been some cases where when their work was being privatised, they tried to take action to secure their existing terms and conditions with a future employer, the employer that was about to take over when they'd been privatised. That kind of action was injuncted in the courts. But clearly it means that workers would not be able to take action in defence of the environment or their surrounding ecology, unless, for example, if workers in a factory were working and they noticed that there were discharges of effluent into, say, a local river system, they would be entitled to take industrial action or to walk off the job if that effluent going into the water system was an immediate threat to them, as opposed to a threat to the environment around them and the watercourse and so on. So again, it highlights how restricted things are. But the point I want to finish on is a very important one. The law is only as good as it can be enforced, whether we're talking about any type of law or laws that govern industrial action by unions. And it was the case for many years up until this, at least the late 1980s, early 1990s, that workers in Britain quite often took unofficial industrial action. There were no ballots, there were no notification to employers. Workers decided themselves in a kind of meeting at the factory gates or in the canteen to walk out after having had a debate about what the dispute was about and what they wanted to get out of it. And in very few cases was action ever taken against any of those workers, including those that were the, if you like, the so-called ringleaders. So we have to bear in mind that while there are significant restrictions on the ability to take strike action or any other form of industrial action, the balance of forces is really the key point as to whether the law will be implemented, but also whether workers will decide to abide by that law and conduct a dispute within that legal framework. The final point I want to make, which again is an up-to-date point, but it's one that's relevant for the issue of occupations that will be discussed, workplace occupations that will be discussed in a future section in this this broadcast, is that the police bill that is currently going through Parliament is likely to have a major impact on the ability of workers to engage in workplace occupations. Not because it specifically says workers will not be able to engage in workplace occupations, but because it changes the rights to do with trespass and increases the fines and regulation of that. And whether it was the Vestas occupation that Vicky Morris will talk about, or the other ones that I talk about in another section at BIFAB or at Harland and Wolff, if this new law comes into being, it will be easier for the employers to ask the police off their own back to fine and ultimately jail those that seek to take over the factory, the workplace, because they will be accused of tampering with and going against property rights as embodied in this new police bill that is likely to become law. So just ending on a point there of again, emphasising the barriers and obstacles that exist, but I still want to go back to that penultimate point that I made, which is that if workers are so minded and do take their action in sufficient numbers that has a critical mass, then quite often the law isn't as important as you might otherwise think it would be. Thank you.